Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we'll be discussing the importance of taking caution with respect to employment standards officers. Now, what I mean by taking caution is that you need to take with a grain of salt what is told to you by an employment standards officer and not expect everything that comes out of their mouth to be precise to your fact scenario. Because as with every government official who is responding to you, in particular those who are responding to you with no prior factual understanding of the situation, you need to be extremely cautious and recognize the disadvantage from which they are operating and providing you with generic answers that are intended not to put the government in a difficult position and for them not to be interpreting the law. It's a very difficult situation they find themselves in. And what they attempt to do is they have a series of manuals, a series of practice scenarios with which they provide standardized answers based on standardized situations, all the while attempting to avoid placing themselves in an adverse position. And unless you get to a lawyer within, you will not get a lawyer's response. And the lawyers there will not give you a response because they are too heavily trained in their ethical responsibilities and professional responsibilities to avoid providing you with legal information where they do not know all the specific facts of the situation. Because as any knowledgeable lawyer knows, a single additional fact can transpose the entire scenario. And as such, when you contact employment standards and you talk to a government official from employment standards, you should not be expecting them to know every fact, having spent the requisite time analyzing the facts in relation to the law in all its possibilities and permutations. That's why you talk to a lawyer who is committed to your case. It's a very different scenario. When you deal with a lawyer, they investigate specific to what you are dealing with. They spend the time, they prep, they don't rush to answers, and they look and investigate thoroughly, and they take their time, hopefully. And that is how they produce their responses. Do you really anticipate an employment standards officer who picks up the phone, doesn't know where you're coming from, doesn't know anything about the fact scenario, to be able to give you fact-specific, precise responses without having received all the facts, analyzing them, assessed the challenges and difficulties in the scenario, gone back and forth, discussed it with others, reviewed not only case law but legislation, and where the basis of stuff may arise? That is a very high hill to climb, a mountain, I must say, that is extremely difficult for anyone to perceive that will be done. Nevertheless, I see lawyers responding back to me and telling me that my clients should go talk to employment standards officers to get the particularities of the situation. Is that really where the answers lie? Yes, they attempt to do their best, but they are imposed and operating under severe restrictions. That is how information officers work. And part of the challenge they face is they do not want to steer people in the wrong direction. And then because of that, they have a difficult task in front of them. And in many respects, they're obligated and they're necessitated and they feel the need to follow standardized answers that seem to fit your fact pattern. And they say it so often, they tell so many people that it seems to come off and resonate with an air of confidence. But is that really the case? I say it is not. It is a best attempt. But there is so much, so very much that is missing from these scenarios, so much that is not taken into account. The fact of the matter is, in many cases, an individual must actually sit back and assess situations. And the truth is that on more than one occasion, many occasions, when I have dealt with government officials who have given information out or who are the gatekeepers to how stuff is to be dealt with, they may initially believe that their answer is correct, but when it goes up the chain and spends the time, the facts impact the situation, and what is put down in the manual, is put down in the information, and is trained with these individuals is actually deemed to be inaccurate, at least for the facts scenario that you are presenting. And that is a critical aspect. This stuff takes time. It takes contemplation, recognition, and an attempt to find where the deficiencies are. And that's another challenge unto them. They are not sitting back long enough. They are not capable of it because that is not their business practice to sit back and say, how do I attack this position? How do I challenge this position? Or do I go with the rote standard information? And that is why I warn you, be very cautious as to overly relying upon what is stated to you by employment standards official especially when you're dealing with them for the first time on the phone. This is something that you have to caution yourself about because it can lead to disastrous consequences for yourself if you do not proceed appropriately and you do not actually get legal advice that's specific to your facts. Your facts are so important. And the fact that other people make this mistake, it should not be the reason why you make the mistake. Hence the caution. And it is a caution that should be heeded, but it is ultimately up to yourself to determine how you wish to proceed. Thank you.